Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to the special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. I'm GB Setusa, and I'll be your host for today's important discussion: what to expect at your immigration bond hearing. Now, when an individual is placed in immigration detention, one of the most urgent concerns for them is whether they may be released while their case is pending. An immigration bond hearing can provide that opportunity, but the process involves specific legal standards and procedures that may not always be clearly understood. Now, understanding how bond hearings work, what immigration judges consider, and how to prepare can significantly help individuals and families who are navigating detention. To help us break this down, we're honored to be joined by Renata Rocha Esquire, an experienced immigration attorney who represents individuals in detention and regularly appears in immigration court for bond hearings and removal proceedings. Attorney Rocha, thank you for joining us today. We're thrilled to have you for this important discussion.
Oh, thank you so much. It is a pleasure to be here today.
And before we begin, attorney, a quick reminder to our audience: immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us on Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding immigration bond hearings. Attorney Rocha, let's dive right in. Now, to begin, can you explain what an immigration bond hearing is and when a detained individual may request one?
Yes, of course. So basically, an immigration bond hearing is a court proceeding where a detained person asks an immigration judge to be released from ICE custody while their case is still pending. So a person can request a bond hearing if they are eligible for release, of course. This is usually applies to individuals who are detained inside the US and are not subject to mandatory detention. And of course, however, some people, such as those with criminal issues or those treated as arriving alien at the border, may not qualify for a bond hearing. So the first step is always to determine the type of detention.
Okay. All right. So, who has the burden of proof at a bond hearing, and what does the applicant need to demonstrate in order to be released?
So that's a good question, actually. And in my experience, the judge places the entire burden on my clients. So at hearings, usually I have to prove, of course, my client has to prove that he is not a flight risk and he's not a danger to the community. But legally, this is being challenged. And some courts say that DHS must justify detention, while others side with judges who keep the burden on detainees. So this matters because the single issue after determines whether someone is released or remains detained. So this is still um, a good question, but usually in practice and in reality, the burden is on the client, on the detainee.
All right. And what does the applicant need to demonstrate in order to be released?
Well, they need to demonstrate that they're not a flight risk and they're not a danger to the community.
All right. All right. So, attorney, is there any significance in where a person is detained in determining whether they can request a bond hearing?
Yes, so where a person is detained can be very important. First, the location determines which court and judge will hear the case.
Yeah.
And practices can vary from place to place, of course. So some courts are more um, rest so some courts are more like restrictive while other courts may be more open to granting bond. And of course the second thing is that the type of facility and how the person is classified can affect eligibility. So for
Yeah.
example, individuals treated as recent arrivals or processed at the border are often not eligible for bond, and of course we are fighting this in court, but regardless of where they are physically held. So anywhere in the country, this can apply.
All
And
right.
third, I would say that transfers between detention centers can impact strategy and timing. So a person may be moved to a different state, which can change the court handling the case and delay the bond process. And then we have to resubmit the motion for a bond hearing. This takes time. So in practice, both the location and classification of detention play a key role in determining whether a bond hearing is available and how the case will be handled.
Yeah. Now, are emergency or expedited bond hearings possible? And when can applicants request for them?
So, emergency or expedited bond hearings are not guaranteed, but they can be requested. A lawyer can ask the court to advance or prioritize a bond hearing in urgent situations. I would say, such as serious medical issues or lack of necessary treatment, prolonged detention, especially without a prior bond review, humanitarian reasons or concerns, such as being the sole caregiver of a child, clear eligibility for release with strong supporting evidence. These requests are discretionary, meaning it is up to the judge whether to grant them. So,
Yeah.
of course, we have to submit strong documentation and clear explanation of the urgency in order to have an approval.
How do immigration judges determine the bond amount? And what factors influence whether it's set high or low?
So, immigration judges have discretion to set the bond amount, and they tailor is based on the individual circumstances. For example, the amount is primarily influenced by two core considerations. One, whether the person poses any risk to the community at all, and
Yeah.
two, whether they are likely to appear for future court hearings. So, to make that determination, judges look at factors such as family ties in the United States, length of residence in the country, employment history or business ownership, availability of a reliable sponsor, immigration history, including prior compliance with court dates or any criminal history. So, if the person has a strong ties, no criminal records, and a stable plan, the bond is more likely to be set lower, and if there are any concerns about risk or non-compliance, the bond
Yeah.
may be set higher or even denied. So the
All right.
goal is to set an amount that ensures the person will return to court while allowing for release.
All right. Now, attorney, what mistakes commonly lead to bond denials?
So several mistakes can lead to bond denials, and most of them come down to lack of preparation, I would say, in my experience. So lack of supporting evidence, for example, not submitting documents like letters of support, proof of address, or employment makes it harder to show stability.
Yeah.
The second thing is that failing to address criminal history. That's very important. So, trying to minimize or ignore past arrests instead of explaining them with certified dispositions can hurt credibility. And of course, no clear plan after release. So, judge wants to know where the person will leave, who will support them, and how they will comply with court.
Mm.
Of course, another very important thing is that not having a sponsor at all. So, not presenting a reliable sponsor with proof of status, income, and commitment is a major issue, I would
Yeah.
say.
Yeah.
And any contradictions can make the judge question credibility as well.
True. True. Now, attorney, if bond is denied, what other options are available?
So if bond is denied, there are still several options available. For example, appeal the decision. We can always appeal the decision. You can appeal the bond denial to a higher authority for review. The second thing is that request a new bond hearing, which is not easy, I would say. So let's be very careful here. It is not easy to request a new bond hearing because we do have to show that the circumstances have changed. So what does that mean? Providing new evidence, providing a new sponsor, progress in the case. You can always ask for a bond again, but this is not guaranteed.
Yeah.
And another option is to seek release directly from ICE, which in this administration is really hard and I would say almost impossible. But well, in some cases, ICE may grant release under supervision or humanitarian considerations. And
Okay.
of course, my favorite one it is pursue federal court relief through habeas corpus. So if the detention becomes prolonged or raises fairness concerns, a case can be filed in federal court challenging continued detention.
All right.
So the key is that a bond denial is not the end of the road. Of course, strategy shifts depending on the facts and how long the person has been detained.
Hmm. Hmm. All right, attorney. So, what practical advice would you give immigrants navigating detention to improve their chances of being released?
That's a good one. So the first advice I would offer it is have a strong sponsor ready. So someone with legal status who can provide an affidavit, ID, proof of income, and a stable address where you will live. The second thing is that show ties to the community. So family in the US, land of residence, children, and any community involvement all helps show stability. That's very important. Another thing it is provide a clear release plan. So where you will live, how you support yourself, and how you attend all court hearings. That's very important as well. The other one is gather documentation early. So have everything ready to go. Letters of support, proof of employment, lease agreements, and any records that show responsibility and stability.
Hmm.
And another tip that I have it is be honest and consistent. So do not hide past issues. They will know and they will tell the judge. DHS will be very ready to show this in court. So be ready to address them clearly and with documentation. Any prior criminal history properly needs to be addressed. So provide certified records and explain the circumstances. This is very important. Of course, another thing that I see a lot in court, it is about having a viable immigration case. So if you have a pending asylum application or a pending adjustment of status or any family-based petition, it is very important for you to demonstrate that you are actively pursuing your case. And of course, last but not less important, it is work with an experienced attorney if possible. So preparation and presentation matter. Bond hearings move quickly and can significantly impact the outcome.
Yeah.
So be ready to hire a lawyer for your case.
Thank you so much for those valuable insights, Attorney Rocha. It's truly been an interesting session so far.
Thank you so much.
Now, for everyone watching, this discussion about immigration bond hearings is not meant to create unrealistic expectations, but to provide clarity about what individuals may face while in detention. Now, preparation, understanding the legal standards, and presenting strong evidence can make a significant difference in the bond outcomes. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is triple B accredited and ISO certified. This reflects our commitment to transparency, community education, accountability, and security. Now, Attorney Rocha, based on your experience, how does ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
Well, it is very important. I'm an immigrant. I'm an immigrant myself, so I know that some people they have a lot of questions. They are kind of lost. They don't know where to go, who to ask. So it is important to have a platform like immigrationquestion.com so you can ask some questions. Of course, you do need a consultation with a lawyer, but sometimes if you read some answers that may apply to your case, you're going to be more calm and it's going to clear your mind and every question that you have. So it is important for the immigrant community to have a platform like immigrationquestion.com. It is very helpful.
Thank you so much for those thoughts, Attorney. Now, Attorney, before we move into our live Q&A session, let's tackle this important question. What is a common misconception individuals have about immigration bond hearings that you believe should be clarified early on in the process?
That this is an easy process. It is not. It is not easy at all, especially in this administration. It is becoming harder and harder to get a bond in a court hearing, an immigration bond hearing. Judges are more likely to deny bond cases, and if you don't have the right documentation and preparation, your case is going to be denied. I understand that being detained it's not easy, especially when you have a family outside that depends on you, financially, emotionally. But I always tell my clients, listen, I'm not going to file a motion for a bond hearing if I don't have every single evidence that I need in order to get you out of detention.
Yeah.
So I need first to gather all the evidence necessary to get a bond based on my experience, and then I will file the motion. They're
Yeah.
all like, oh, Attorney Renata, please file the motion. I just want to get out of here. It's horrible. I'm not eating, I'm not sleeping, I miss my family.
Mm.
It's a horrible situation.
Yeah.
Yes, but you need to be ready. Remember when you asked me about what mistakes tend to lead to bond denials,
Mm.
and I say lack of supporting evidence, not submitting documents like letters of support, proof of address, or employment makes it harder. Yes, when we go to a hearing, we need to be ready. The
Yeah.
judge is going to ask, okay, why should I give you a bond?
Mm.
What's the reason? So
Yeah.
we need to be ready to address every concern. And
Mm.
remember, DHS, they're going to be ready to
Yeah.
attack you, to have every evidence against you. So it is very important to prepare, have all documentation ready. And another thing that is very important that I would say is that even if you are not detained before, of course, nobody's expect to be detained, but if you are an immigrant, be ready to apply for a case, talk to a lawyer, see if you qualify for a case. Because once you're detained, in order to get a bond, the judge is going to ask, okay, what type of case you have pending?
Mm.
Do you have any pending case? If you
Yeah.
don't have anything, it's going to be very hard to get a bond. So
Yeah.
I would say talk to a lawyer as soon as possible. Don't wait until you be detained in order to apply for any benefit that you may qualify for. So
Yeah.
that's my advice.
Thank you for that. Now, if you're just joining us, we've been speaking with attorney Renata Rocha on what to expect at your bond hearing. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Please drop your questions in the chat or call us live at 516-703-3483 and we'll take as many as time permits. All right. The first question: what exactly happens during an immigration bond hearing from start to finish?
Well, bond hearings are usually very fast. It goes fast. So of course, if you're represented, if you have a lawyer, the lawyer is going to talk on your behalf. The judge is going to ask what language you speak, if it's Spanish or Portuguese or any other language,
Yeah.
and the judge is going to basically say, okay, why should I give you a bond? Why you should be released? And then the lawyer have to be ready to address every question: flight risk and danger to the community. So
Yeah.
basically saying, well, my client should be released because he's not a danger to the community. He does not have any criminal record, does not have a criminal background. He does not have anything. He was detained because he was driving without a license. Okay, but we can always argue that driving without a license does not make you a danger to the community. And also, my client is not a flight risk. He has a U.S. citizen children. He has a pending asylum application. He has a employer. He has a job. He has a life. He paid taxes. So it's basically like that. And then, of course, DHS is going to be, oh, I do not agree. I think this person it is a flight risk. It is a danger to the community. And the judge is going to be like, okay, I think this and that, and I'll give you a bond, $10,000, for example.
Yeah. All right.
Of course, this is
Second.
a simple case, but if you have harder cases, it's a little bit different. But usually it's like that.
Yeah. Right. Second question. How does the judge discuss whether I am a flight risk or a danger to the community? How does the judge decide whether I am a flight risk or a danger to the community?
So that would be, for example, flight risk, family ties in the United States. Do you have any family here? Second, length of residence in the country. You just arrived 6 months ago, or you've been in the United States for 10 years, 5 years, which is more time, and you have a life, right? Another thing is that it is employment history or business ownership. You have a business, you have employees, you generate income, you help the country. So you have every reason to stay in the United States and comply with all the court hearings. Another thing it is availability of a reliable sponsor. A United States citizen or a green card holder is going to tell the court, hey, listen, I'm a US citizen and I promise you that this person is going to show up for every hearing that they will have in the future. So this person guarantees that the alien is going to appear in court. Another thing is that immigration history. Like I said, do you have a pending case with the USCIS or in court? Do you have any asylum? Do you fear to return to your country? What do you have? Do you have a path to legalization in the United States? Yes or no? So judges look at whether you have a pathway to become a green card holder in the future or a United States citizen. And another thing is a criminal history. Like I said, are you a criminal? Do you have a, how is your background? Have you committed any crime in the past? And if so, what type of crime? This is very important. So if you don't have a criminal history, that matters a lot. That helps you a lot.
All right. What kind of documents or evidence should I bring to increase my chances of being granted bond?
Well, I would say letters of support from affidavit of support. So, for example, you have a friend who can testify that you have a good moral character. So the friend will write a letter, hey, judge, of course, not using this language, but basically saying, hey, judge, this person is a good person. He goes to church, he has a house, he has a family, he has a job, and I can attest before this court that he's not a flight risk, he's not a danger to the community. Another evidence, your taxes. Do you pay taxes? Let's bring it to court and show the judge that you pay taxes. You've been complying with the laws of the United States. Another evidence that I always bring is that criminal background. So whether you have a background or not, we have to show the judge that you are not a danger to the community. And I always update pictures of my clients with their families and children, so it can touch the judge's heart. It is also helpful. So I always submit some
Mhm.
evidence and pictures of my clients with family and friends and going to church. But of course, receipt notices. If you have a pending case with the USIS, like I said, we always submit a receipt notices showing that you do have a pending case and you have a pathway to a green card in the future. And basically,
Yeah.
these documents are very important.
Thank you to everyone who joined the special edition webinar, and thank you, Attorney Rocha, for sharing your knowledge and practical guidance with us today.
Thank you so much for the opportunity.
Thank you. To everyone else, you can always visit immigrationquestion.com to ask immigration related questions, stay informed about policy updates, and register for upcoming live events. If you missed any part of this important discussion, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Wednesday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye bye.